I've read through the comments and the language for 6 and 7, but I don't think we're going to get past 6 today. And if we get to the end of 6, then I would just suggest that we call it for the day. You know, because 6 is a new thing, so I expect that we'll have some discussion about it. But it seems to me to be a fairly non-controversial thing. So, and David may have additional thoughts. But yeah, sorry.
I totally agree with you. I think it's non-controversial, but it is introduction of a whole new thing to the our statutory scheme, which we don't currently have.
Yeah, and so I think I will consider it a win if we can get through the rest of 5 and the few sections of 6, and then we'll just call it a day, understanding that everybody's got other stuff going on that needs to take priority. We got an email from Kathy too, so her daughter has some health challenges right this morning. So okay.
And, really quick before we get started, in case we do have to end abruptly, we do have another meeting scheduled. It should be on your calendars for October 6th. So just FYI on that. We can hold off in November, or we can do it at the end of this meeting.
Why don't we try and get November on the calendar, as long as we've got everybody here, assuming the world doesn't end between now and then.
There's a possibility of that.
I am aware.
Shall we make it after November 3rd?
Yeah, let's make it after November 3rd, just out of abundance of caution, shall we?
Maybe we'll be feeling better after that.
Or
hopefully.
We might be perpetually drunk, one of the two.
Yeah.
Well, that's the thing. I mean, we just have not been willing to drink because we're thinking we might get evacuated any moment driving the car.
Yeah, it's not like a hurricane party, right? Where you're not going anywhere.
Well, we aren't going anywhere. But anyway, yeah, let's check our calendars.
Well, you're always welcome to come evacuate to my little ranch house in the burbs. So.
Thank you.
And drink with Valerie.
So Valerie, do you have a prospective date for November?
November. So I'm the 12th looks good to me. Thursdays generally seem to work for folks.
Sure.
Does anybody
November
have any?
12th work.
Okay, let's just put it on November 12th then.
All right, so I'll set that tentatively, and I'll send out a calendar invite soon.
Yeah, the only concern is the day before a holiday, Veterans Day?
It is. Well, for some people.
UO does not get off, but a lot of people do.
Okay, nobody's planning on taking vacation that week? I mean, it's just weird.
How do you take vacation nowadays?
Yeah.
Good point.
That's right. It's 11/11. That's the 11th day and the 11th. That's the Armistice Day. Yeah.
Mm-hmm.
Yeah.
Well, let's leave it on the 12th. And then if the folks who can't make it have problems with that, I'm okay with moving it too.
Okay. We'll tentatively send it out, and if we need to reschedule, that's fine.
Yeah.
And I saw Susan joined us. I see, just FYI, Victoria from the Department of Revenue is on the phone, and then just for everyone's, I see Jamie is here from Secretary of State, and Willie from the Department of Revenue as well. Otherwise, it's the folks who've been here for us at the beginning. So Valerie, actually, I guess Teresa, you're up.
Okie dokie. So I wanted to start with one follow-up item from the last meeting on section 502H. When we talked about that, I pointed out that I thought the nearest analog to that statute was ORS 63-249 sub 4. But after the meeting, Cody pointed out to me quite correctly that there is also an analog in ORS 63-255. I do think that this section H is consistent with both of those statutes. They're similar, not exactly worded the same, but they're similar. And I still recommend that we adopt 502H. I just wanted to bring that extra Oregon statute to your attention in case those of you who are playing along are keeping track of what you think the analogs are.
Well, and I think that's useful too when we're thinking about how do we put together materials for teaching people about this. So thank you both, Teresa and Cody.
Yes, thanks Cody for sending me an email about that because I had just overlooked that. So now we get to the part that I'm most excited about of the entire thing of everything we've talked about, which is section 503. And I am so happy with section 503 that I'm going to tell you right up front, I'm hoping we're going to adopt it as is.
Well, a lead in like that, how could we do anything but?
Right. So section 503 deals with charging orders, which is the primary method by which one collects money owed by LLC members. And I think it's first useful to point out what charging orders don't do. If you have a member of an LLC that receives a salary or wages and also receives distributions, the charging order only applies to distributions. If you want to try and collect from somebody's wages that they receive from an LLC, you use the garnishment process in Chapter 18 of ORS. So we're going to put that garnishment thing aside because that's similar to any wage garnishment from any entity, whether you're an owner or not. And that there isn't anything really for us to do with that. So when we talk about charging orders, what we're talking about is the member of the LLC owes a creditor money, and the member of the LLC is entitled to receive money at some point from the LLC. And what the charging order does is allow a creditor to put a charging order against the membership interest, and that tells the LLC, instead of paying the distribution to that judgment debtor member, you must pay that distribution to the charging order creditor on the judgment debtor's account. So it's a useful remedy. It's something that's very important. ORS, a current version of ORS in Chapter 63-259 is our current provision on charging orders. It's 3 sentences, which I wish it were a lot more robust and a lot more explanatory. And that's why I'm so excited about section 503, because it really clarifies a lot of things that we don't currently have clarified. So currently what ORS 63-259 says is that the court can charge the membership interest. To the extent charged, the judgment creditor has only the rights of an assignee, and that it doesn't deprive the member of any exemptions that they may have under applicable law. That's fine as far as it goes, but it doesn't go very far. So one thing that's always important in this area of the law is that judgment creditors are not interfering with the pick your partner principle. As a practical matter, judgment creditors don't generally want to become involved in the ownership or operation of the LLC, and nor do the other members of the LLC want judgment creditors to do that. So the way it typically works is you're entitled to distributions, and that's about it. If you're a judgment creditor, you get a charging order that does not give you rights to control what the partnership does, or give directions about when the partnership should issue distributions, or what the partnership, or excuse me, the limited liability company should invest in, or what the limited liability company should do with its business. And there's an Oregon case that came out in 2018, and the reason I was thinking about limited partnerships is because it dealt both with limited partnerships and LLCs, Law versus Zemp, which was 362 OR 302. And that case talks a lot about the scope of permissible charging orders, what you can include in a charging order and what you can't include in a charging order. And it basically follows the principle of you can include what you need in order to make sure that the distributions get to the right creditor, but the creditor doesn't get to interfere with the management or operation of the limited liability company. And that, I think, is a correct decision.
Teresa, can you give me that site again? I missed it when you said it.
Sure, it's 362 OR 302.
Okay.
2018, Law versus Zemp.
Okay.
So that's really the leading case in Oregon on this subject. And when you get to the bottom of that case, there are aspects of it that they sent back to the state court, or sent back to the lower courts to say, well, you didn't make a good enough factual record to show you were entitled to some of these provisions, but you might have been able to obtain them. Other provisions, you just weren't able to get at all. And some of that had to do with, you could prove a right to get information to ensure that you were actually getting the distributions you were entitled to if you put on the right factual case, but you're not going to be able to get the right to tell the limited liability company that it can't make certain investments, for example. So that's the background legal context that we have in Oregon for going through Section 503, which is almost entirely new material. So I thought we would start at the top with Section 503A, which essentially picks up the fundamental concept that a court can enter a charging order against the transferable interest of the judgment debtor for the unsatisfied amount of the judgment. So that, to the extent it says that, it's pretty much the same as the first sentences of ORS 63-259. And then the second sentence is new and useful, because what it says is a charging order constitutes a lien on the judgment debtor's transferable interest and requires the limited liability company to pay over to the person to which the charging order was issued any distribution that would otherwise be paid to the judgment debtor. The second half of that sentence is sort of obvious in the context of what a charging order is and does. The part that's new and useful here is that it actually clarifies that the charging order is a lien. And before, it was not always clear that it was a lien or should be treated like a lien, but this is particularly useful in looking at how liens are treated, for example, in bankruptcy. You can do certain things with liens in bankruptcy if you know that they're liens. So now we aren't going to have to argue about that anymore. So that's helpful that we've actually clarified the nature of that as a lien. So for example—
Teresa, could I ask
yeah.
Could I ask a question? So if it's a lien, I'm thinking about a bad actor member of an LLC who tries to sell the rights to distributions. How would a third party have notice of the lien?
A third party would have to find the underlying court case. They'd have to do their due diligence on their seller to see if they were a judgment debtor in any case, and then determine if there were any charging orders entered against that judgment debtor.
I wonder, this is just a question, lien priority. So, you know, how would it be determined between this lien and, let's say, just a general, you know, blanket lien over the judgment debtor that's all personal property, etc.? How would anyone determine who has priority between those two liens on these distributions?
I think you would look to lien law, which would tell you first in time, first in right. So if for example, the judgment debtor had already pledged their membership interest to support a secured debt, and that secured lender already had an Article 9 security interest against that, then that lien would exist, and the charging order would come in, if it was issued later, would come in behind it.
Would you need to record would you need to do like a UCC financing statement to perfect this charging order lien?
No, because the UCC financing statement concept is something that is derived from Article 9, and this would not be an Article 9 interest. So for those people who were representing purchasers of LLC membership interests, it would not be enough to do your due diligence by simply running an Article 9 search. You would also want to run a search in the court records to determine if any judgments had been entered against your LLC member that you're purchasing from. And then you would want to check the docket in those cases to see if there were any charging orders. And frankly, that would be true now. I think even if you had a member that had a charging order against them and then tried to transfer that membership interest, I think the judgment creditor's right would be superior to the buyer's interest, because that charging order had already attached that stream of payments.
Right. Well, I was just thinking about, oftentimes maybe, maybe it's just something that we would have to weigh the potential case, but oftentimes with unrecorded liens, like for real property, for example, they're only applying to people who have actual notice of them. And so, an unrecorded lien, and I guess it's recorded in a sense that it's entered in a court docket somewhere, but isn't it true that any court can enter a charging order? If somebody gets divorced in some county in Kentucky and that court ends up entering a charging order and in favor of the creditor spouse, then how would somebody dealing with that, divorced business person here in Oregon know to look up the Kentucky County State Court record for a charging order?
I think they're going to have to do their homework because the creditor has already attached that stream of payments. And I mean, typically, I think on the transactional side, you would have your seller make representations and warranties about the fact that they are, the sole owner, that it's unencumbered, that they're entitled to transfer it, that there's no one else who has a claim against that interest. You always have the problem of the bad actor, the person who lies, but that's not a reason to cut out the creditor who already has a charging order.
Well, yeah, I just was curious.
Yeah.
But there is a third-party purchaser issue here in terms of notice. And Cody paints a good picture of how's a bona fide third-party purchaser going to know. I mean, that's why with recording, you record in the county of the property, and UCC, obviously you file it with the Secretary of State. So look, Cody paints a picture of you don't necessarily know where to look.
Well, but so would a charging order currently be recorded in any form?
No, a charging order would typically only show up in the court where it's entered.
Yeah,
I mean, this problem exists now, Jeff.
Yeah, it's not changing the problem. I mean, we put reps and warranties saying that there's nothing like this out there when we're doing deal documents, right? But it's one of those things that it should be on a due diligence checklist.
Well, but
and
the language, there is a distinction here between the current language doesn't refer to a lien, and the new language clearly it's a lien. So. Yeah, I know that the situation I just described currently exists as well, but there's a distinction here in the sense of is where we are right now. Is it a lien or is it just a charging order?
Teresa?
Right now it's unclear, which is not helpful.
Let me ask a question related to that, Teresa, because it might help provide clarity of how unclear it is right now. Let's say there's a charging order against a member's interest, an individual, and they file, say, a Chapter 7. Are you the person, the creditor that holds the charging order, do they get in the secured or the unsecured line? What's the status of the law today in terms of whether it's treated in let's say the federal district court in Oregon, a bankruptcy is filed, would they treat a charging order as the creditor as a secured or an unsecured party? Which line do they get into?
Under the bankruptcy code, the debtor's property that goes into the bankruptcy estate is only what the debtor has rights to at the time that they file. So at the time that they file, the debtor does not have rights to the distributions. The creditor does. So the rights to the distributions don't go into the bankruptcy estate, is how I would analyze that.
So your creditor in that case doesn't need to file a proof of claim in the case and participate in the case to protect their interests because the asset charging order is outside of the bankruptcy. They don't need to participate.
Well, they probably would file a proof of claim in order to be able to collect from what other assets that the debtor has, because they would want to participate in the case. I mean, they don't want to be limited to just the LLC membership interest. They are a judgment creditor. They have a lien on the debtor's real property in any county where the judgment is recorded. They have a charging order against a debtor's LLC membership interest. Presumably, to the extent that they're not secured, they would be entitled to a distribution on account of their unsecured claim. So they're going to participate in the bankruptcy case probably anyway. But the question comes up because under section 522 of the bankruptcy code, a debtor can expunge a judgment lien to the extent it impairs an exempt interest. So the typical example is if somebody has a bunch of judgment liens against their house and they have a homestead exemption that is impaired by those those judgments, they can expunge those judgments to the extent it impairs their homestead exemption. So to the extent it's an involuntary lien, you can expunge it under 522F. So what this would do is make clear that a debtor could do that, which I don't think is as clear as it could be now.
So Teresa, continuing on Cody's hypothetical with our Kentucky judgment, wouldn't an Oregon court want that judgment to be transcribed in Oregon before it would issue on that Kentucky judgment a charging order?
Yeah, a state court order can only have power as far as a state court's borders. So typically, if a judgment is entered in Kentucky, in order to enforce that judgment in Oregon, you would have to have it entered in Oregon.
So that, I think that provides the basis for finding the judgment on the record, it would seem to me.
Right, and I think you have to look at, and there was something in the commentary about this that I was looking at, that this section by its terms doesn't apply to foreign limited liability companies. So this applies to Oregon LLCs. So if you want to get a charging order against an Oregon LLC, you have to take your foreign judgment and move it to Oregon and then issue the charging order out of an Oregon court.
Right, but I guess and maybe this is just sort of, be careful, anyone who is taking a lien on or buying, a person's sort of general intangible personal property. But, you could have that person, let's say the husband, he's living in Oregon, he's got this Oregon LLC, he's got a membership interest in it, but he's separated from his wife who's still in Kentucky, and she files the divorce action in Kentucky and gets a divorce judgment in Kentucky, and he isn't paying her, and she gets a charging order in Kentucky because that's, where she's got her judgment. And then, she gives the LLC notice of her charging order from the Kentucky court. And then you have, separate from that, somebody here in Oregon who is going to, maybe make a loan to this husband, this ex-husband, and wants to have a sort of, a blanket lien on their personal property or something like that, or they want to buy this person's membership interest or something like that. How are they going to know about this charging order, which is still going to be binding on the LLC, regardless of whether it's filed or recorded in Oregon?
Actually, I'm not sure about that, because in order to get a charging order against an LLC, the Kentucky court is going to have jurisdiction over that LLC. So unless the Oregon LLC has gone into Kentucky and subjected itself to Kentucky law, I'm not sure that it can do that, because it's not going to have jurisdiction, because a charging order is issued against the LLC to say, when it's an order against the LLC that says, LLC, when you're going to make payment to Joe judgment debtor, instead of paying Joe judgment debtor, you have to pay judgment creditor. But you get that order against the LLC. And so you have to haul that LLC into a court where there's jurisdiction to do that. And the Oregon LLC you're positing, I think you're skipping over the part where the Kentucky court actually has to have jurisdiction and enter that order against the Oregon LLC.
Okay.
So then doesn't the judgment creditor simply have to take the Kentucky order and go to Oregon and get full faith and credit and force it in Oregon? Is that
right?
the process?
And then you can find it in Oregon.
Right. Okay. So you extra step to get essentially jurisdiction over the Oregon LLC and get it to comply with the order.
Right. Right. I think that would be the easiest way to do it, because typically you're not going to be able to find a hook to get an Oregon LLC into Kentucky, unless for whatever reason it has a lot of operations there or something. But, we're talking our typical small LLCs. You're going to have it's most likely somebody's gonna have to come into Oregon in order to get that charging order. So.
Hey, this is a dumb question, but if you representing a buyer and they would do your standard UCC search, which would include going beyond just state filings, but look at county filings and et cetera, and you expanded it broadly enough to include judgments and that sort of stuff, would the charging order show up on that search?
The judgment itself would show up on that search.
Oh, okay.
But then what you would have to do as the lawyer doing due diligence is take the extra step to actually pull the docket in the case where the judgment was entered and see if after the judgment was entered, a charging order had been entered after that.
Okay, so actually the showing that there's a judgment would be a red flag in and of itself, so.
Right. I mean,
Right.
At that point, you're going to want to look at it anyway.
Right, exactly, yes.
to see if there's some reason you don't want to be doing business with this person.
Right,
So,
thanks.
but I think
So
it
I
does
guess
help.
can I ask one more question? I was just
Yeah.
looking at the comment on page 127,
Yeah.
where it appears a Minnesota court said, hey, this LLC is Cook Islands LLC. So it's, this was a Minnesota court, and they're like, this is not a Minnesota LLC at issue here. And because of that, and because this charging order restriction only applies to Minnesota LLCs, we're going to kind of let you do whatever you want with this debtor's interest in their foreign LLC. And so, given that, I'm just curious how this impacts things, because let's say that you have this business dealing with Oregon people, but maybe it's a Kentucky LLC that your judgment debtor is a member of, and so then can the Oregon court, order something more extensive than a charging order as to that Kentucky LLC, like it appears this Minnesota court allowed? Or did the Minnesota court forget about the issue that you mentioned, that you would need to domesticate this Minnesota judgment in the Cook Islands before you could take action? I mean, because a charging order by itself doesn't seem to me to strike so much at the internal affairs of the LLC. It's just telling them where to, make the check payable to.
Yeah, I did not read this underlying case that's referenced in the comments, but I think that if in your hypothetical, you could get jurisdiction over the Kentucky LLC, let's say it had operations here or something where you could actually get jurisdiction over it, then I think it's a choice of law problem, and you may have to look to Kentucky LLC law to see what kind of charging order you can issue against this entity. I think that's what this is saying, is that the Minnesota court was looking to Cook Islands law to see what they could do rather than looking to Minnesota law.
Okay.
And to the extent we're considering these provisions, I mean, I love these questions. They're really interesting. I'm learning a lot. Teresa knows everything, but we're really, are we just
premise to start with?
But we're looking at the statute for purposes of adopting it for Oregon. So it's going to be Oregon law. And I don't see how that's going to affect the ability of judgment creditors against foreign LLCs.
No, yeah, I didn't mean to say we shouldn't adopt Section A. I think we should adopt Section A. I just wanted to understand, like Jeff was pointing out, now that they're sort of explicitly calling it a lien, I was just trying to, part of me was wondering, is this not being explaining enough? Oh, we've made this change, now it's a lien. Do we need to be explicit about how you do notice and priority and things like that? But
and I'm sure we're going to get to this, but paragraph H talks about Article 9 and how this doesn't change any of the remedies that are available for secured transactions. But I'm sure we're going to talk about that.
Yeah. So I do think that by calling it a lien, it puts it in a conceptual framework that makes sense, that we don't really call it now, what is this creature? Well, it's a charge on an interest in an LLC, and a charge is really what a lien is. Well, why don't we just call it the same language that we use for everything else? So in my view, this is an improvement because it clarifies the law. So for Section A, I recommend that we adopt Section A.
I agree.
Yep.
Okay.
And I think that the fact that Section A talks about the unsatisfied amount of the judgment without saying with interest, like the Oregon statute does, I think the with interest is implicit. So I don't think this is a change in the law.
I agree with that because the judgment includes what the judgment includes, and some include interest and some do not. And some people are much better at writing judgments than other people are, which always astonishes me. So Section B says, to the extent necessary to effectuate the collection of distributions pursuant to a charging order, the court may, 1, appoint a receiver with the power to make inquiries that the judgment debtor might have made, and 2, make all other orders necessary to give effect to the charging order. I think this is particularly useful, and I think it really addresses a lot of what Law versus Zemp was trying to address, which is what is the scope of permissible orders that a trial court can make to aid in the enforcement of a charging order. Because here's the problem. If you have a 2-member LLC, guy and his best friend, judgment debtor and his best friend are an LLC, and you're trying to collect from judgment debtor, what happens is you get your charging order, and then guy and his best friend decide that they're never making another distribution again in the history of the universe. That they are going to, instead of making a distribution to the owner to buy a boat, they're just going to buy a boat in the LLC. Or instead of, making a distribution, they'll just suddenly pay everybody's salary and they won't make any distributions anymore. Or instead of making a distribution, they'll buy a vacation home that guy and his best friend are going to be able to use. So all the stuff these people would have done personally, they just do in the LLC. Has nothing to do with the LLC's business, but it's a way of trying to avoid the charging order. And what happens is the creditor always gets wind of this, right? They hear about the boat or the vacation home and they say, well, wait a minute. How can he be, living large on the boat or spending time at the vacation home when I have charging order on all the distributions? So I want to know what's going on here. How are these distributions going around me? And the LLC's, maybe they're just paying the judgment debtor and ignoring the charging order, or what's going on here? So what's nice about this is that it allows the use of a third party to obtain that information in a way that doesn't interfere with the operation of the business, to see if what's going on is really what should be going on. And I think that's an improvement in the law. Because right now, what happens is you get what people tried in Law versus Zemp, which is, I want the state court to issue an order that says that the LLC can't invest in vacation homes. Or I want an order that says the LLC has to make distributions. And all of those interfere with the LLC's right to do whatever business it wants to do. But I certainly understand why creditors ask for that, because they see these types of abuses, and we do see these types of abuses. So I think this section strikes a nice balance because, first of all, it has this lead-in clause, which says to the extent necessary to effectuate the collection of distributions. So it's saying, for this limited purpose of making sure distributions go where they're supposed to go, you can get somebody to get this information for you. And the court can issue orders that are in aid of the collection of the distributions. But it does not give a judgment creditor carte blanche to do whatever they want to interfere with the operation of the LLC.
I'm a little bit concerned about B2. So let me just plant a scenario and see what your thoughts are. There are lots of good reasons why an LLC may have cash not to make distributions. And I would be concerned that somehow B2 could be used to effectively require an LLC to make a distribution where it's not in that abusive situation, where it may have a lot of cash, but it's not buying the boat and the house inside the LLC and letting the member use it. So we don't have a scenario is B2 too broad? Does it give a court, the authority to require distributions where I don't think that would be appropriate?
Yeah, I think that that's really addressed in the comment to subsection B2 in the first example, where it talks about a judgment creditor who thinks the LLC should, do less in investment and leave more money to distribute in cash, and asks the court for an order directing the company to do that so there'd be more cash, so there'd be more distributions. And it makes clear that subsection B2 does not authorize the court to grant that motion.
Okay, so I'm looking at that language though, Teresa,
Yeah.
and it's the very last sentence. It just says, does not authorize the court to grant the motion. So I don't know who wrote the example. It says that, but it doesn't necessarily mean B2 can't be supported. I mean, that's a very conclusory statement. It just says B2 does not authorize that. Well, there's a lot of creative lawyers, including on this call, who could argue to the contrary, and I don't think that example language would be binding. I mean, it doesn't say why.
Well, but also I think B2 is pretty much identical to what current Oregon law is under law versus ZIMP. I know that other order is necessary to give effect to the charging order language isn't in our LLC Act, but essentially identical language is in a different statute that has to deal with the power of the courts to make orders that are necessary, sort of ancillary orders. And that statute was discussed a lot in ZIMP. And the court really carefully, I thought, drew the line along the lines of what Teresa's talking about between giving effect to the charging order and stopping people from doing shenanigan and runs around the charging order. For example, calling distributions loans loan repayments all of a sudden, or what have you, compared to, so you can stop that kind of business, but you can't ever force a distribution just in general. I thought the ZIMP decision was pretty clear about that. And I don't think that the language of B2 is any different from what Oregon law currently provides.
And I think this is one of those places where we should have a comment that says we are not intending to displace law versus ZIMP, we intend for that to remain the law after the adoption of this, because I think it's really limited to the extent necessary to effectuate the collection of distributions. That's not the same thing as to the extent necessary to effectuate the collection by causing distributions to occur.
Or to effectuate the distributions.
Right.
You're saying the words
of distributions that are already occurring, which the LLC on its own should get to decide whether it's going to make distributions or not.
I like this this section B in general. The and I think B1 is also a significant improvement over current law. The only thing that I have an issue with is this requirement that if you want to get the information, you need to have a receiver appointed. So then the judgment creditor now is having to pay someone $300 or $400 an hour or whatever to essentially make some discovery requests. And I don't know why we need to interpose a receiver in this scenario for the creditor to pay out all that, like they're already not being able to collect. And I don't know, I guess I'm just not sure what the abuse is that we're worried about, that we need this neutral third party to ask for the information. I mean, if the receiver is empowered to make all inquiries the judgment debtor might have made, it's not like we're having I don't anticipate a court to referee whatever the inquiries it's obvious. The statute says what inquiries that the member can make. So why not just let the creditor make those inquiries directly rather than having to go through the delay and cost and expense of having a receiver appointed for this purpose?
I don't think that's exclusive because it's 1 and 2. I think a receiver is one option, but I also think that you could take a judgment debtor exam of the LLC and get the same information under chapter.
But you can't do a judgment debtor exam of the LLC because the LLC is not the debtor.
you can take a judgment debtor exam of anybody. Anybody who has information on the assets of the judgment debtor, you can take a judgment debtor exam of. Judgment debtor exams are not limited to judgment debtors.
Well, okay,
I went
right.
I took the judgment debtor exam of Ma and Pa debtor, their 3 sons and grandma, to find assets.
You're so mean, Teresa.
But I think
Defrauded our client of $2 million.
I think that most courts reading B1 would think, I cannot authorize the judgment creditor to make all inquiries the judgment debtor might have made.
See, I think that would fall within all other orders necessary to give effect to the charging order. I think
Right.
you could issue a judgment debtor exam order of the LLC. I don't think you would have to do it through a receiver. I think the reason that they put it through a receiver is because you sometimes have the situation where the LLC members, like, okay, you have judgment creditors who are people like banks, right? Faceless third-party entities with no stake in what's going on with the business. But sometimes you have judgment creditors who are disgruntled business partners, ex-spouses, competitors in the industry, and the LLC would be rightfully concerned about those people having direct knowledge about the finances of the LLC. So that's the kind of situation where I would see the appointment of a receiver making more sense than a judgment debtor exam, for example, of the LLC.
Right.
Right.
You know, in that kind of scenario, that would make sense. I just have a great fear that if we leave the language of B alone, that courts would never authorize the judgment creditor to make all inquiries the judgment debtor might have made. And I would suggest, if we think that that is implicit, I'm worried that it isn't implicit at all. And in fact, it's sort of implicit the other way. And I would want us to put it into the text so that the judgment creditor can make the court can order that the judgment creditor can make those inquiries. If that's the result that we want. I just personally don't think that's in the statute. I think the statute as currently worded excludes that. And so I think if we were just to adopt B as is, then courts will not be ordering that judgment creditors can make the inquiries the judgment debtor might have made.
Couldn't you ask for that as part of the charging order itself? Sorry, Teresa, go ahead.
I just think that they aren't going to do that because they're going to look at B1 and say the only person that the statute allows to make the inquiries the judgment debtor might have made is a receiver.
What about, is part of the issue the use of and there? Would or be better?
No, and I think and between 1 and 2 is good.
Both. I guess the question is what language would you want in here? Something that says that this statute does not preclude a judgment creditor from obtaining information about its judgment debtor in any lawful way. I mean, I'm not opposed to that.
I just don't see how B2 doesn't cover this. I mean, I think the point is, as Teresa explained, you've got your 2 different categories of judgment creditor, and I think there are important differences between them. I don't see how a court could read B2 as precluding. I mean, it's all other orders necessary to give effect. I mean, frankly, if I were a judgment creditor and I just got my judgment and I'm asking for a charging order, you know, the first section is talking about pay me all the money. The second section is talking about I want financials every month as they're delivered to everybody else. Yeah. I want tax return information in a timely manner. And I want, you know, production of whatever documents are within the reasonable realm of what that particular creditor should be entitled to. And I don't think we want that as a matter of right, because I do think you've got those situations like divorcing spouses and burnt partners where they would misuse that information. So I think B2 is the right way to solve that.
So you think that B2 I mean, maybe I'm alone in this, but everyone else thinks that implicit in B2 is the ability of a court, when necessary to give effect to the charging order, to authorize the judgment creditor to directly make the inquiries the judgment debtor might have made.
Yeah. So
I certainly think that.
yeah, and the commentary on page 127 to subsection B says paragraph 2 refers to other orders rather than additional orders. So given appropriate circumstances, a court may invoke paragraph 1, paragraph 2, or both.
Right. Well, I just feel like we ought to add a comment to our own thing then, explicitly saying that the receiver is not the only person who can be authorized to make these inquiries the judgment debtor might have made. Because I have a great fear that courts will otherwise sort of read the statute more the way I am than the way you guys are.
Mm-hmm.
I'm fine with that idea, that we add that comment.
Yep.
I'm taking a note on that since.
I tend to agree with your reading, Teresa, but I hear Cody's concerns, and I think a comment can clarify to that extent.
Okay, so I think unless anybody objects, we should adopt B with a comment. Okay, thumbs up. Okay, so paragraph C talks about.
Sorry, I apologize. I apologize. But one other thing, this sort of, and I mentioned this briefly back when we were discussing section 410, which is about the members' rights to information.
Right.
And 410G says, subject to section 504, which relates to dead people, and we'll cover shortly, the rights under this section do not extend to a person as transferee. And maybe that's not relevant because the holder of a charging order is not yet a transferee. But I just was wondering whether that intro to 410G should say something like, I mean, maybe it doesn't because you're not a transferee, it's just the holder of a charging order. Part of me was wondering, should we say subject to section 503 or 504, the rights of this section do not extend to a person as transferee? But maybe I just answered my own question. Maybe we just leave 410G alone because if you have a charging order, you're not a transferee. Is that right?
Well, and you raise an interesting point that we're going to get to, which is there are provisions in here to be able to foreclose upon and become a transferee after obtaining a charging order. We're going to get there. But in some ways, you do lose rights if you do that. But we'll get there when we get there. So it's a valid point for that purpose. So subsection C says, upon a showing that distributions under the charging order will not pay the debt within a reasonable time, the court may foreclose the lien and order the sale of the transferable interest. Except as otherwise provided in subsection F, the purchaser of the foreclosure sale obtains only the transferable interest and does not thereby become a member and is subject to section 502. Starting with the exception in subsection F that has to do with single member LLCs. So let's put single member LLCs aside for the moment. We're talking about multi-member LLCs where there are other people with interests involved in owning the LLC.
Can I, fundamental question, I just don't know this area at all. Can we currently, under current Oregon law, actually foreclose and take ownership, or is just the right to receive distributions? I mean, the question is this a fundamental change? And now you have the right for a charging order for distributions and the right, if it's, quote, a reasonable period of time. We'll have to talk about what that means. But is this a fundamental change to Oregon law where now you have a right to actually take ownership where under current law you don't?
I'm so delighted you asked that question because that is actually such an interesting question. In most states currently, you cannot foreclose an LLC membership interest.
My understanding.
But our LLC statute has been non-standard for a long time. And there is a non-standard provision in it, which I am just blanking on where it's at, which allows for the foreclosure and sale of a membership interest. Most of the time, I will tell you that judgment creditors do not want to exercise that right. And the reason is, and I have answered this question for clients many times, well, why can't we do that? Well, you can do that. And then you will own that LLC membership interest and whatever nasty tax hairballs come with it. And you don't know what those are. Do you really want to own lots of nasty tax hairballs? And they all go, no. So it's rarely done. And that's the reason it's rarely done, is because you don't know what you're getting yourself into, whether there's a big tax bill that goes along with that. But I have seen it done to great effect. One of like the coolest moves I ever saw another lawyer do, I was representing a buyer in a case of an asset. And the owner of the asset was in Chapter 11. It was a single member LLC. And it had been fighting with a bank lender, which prior to the Chapter 11 had started an Article 9 sale against the owner's membership interest, as well as, or judgment debtor, judgment sale, execution sale, I can't remember which it was, as well as a foreclosure against the asset itself, which was owned by the LLC. And the judgment debtors did not realize that the Chapter 11 would not stop the sale of his membership interest. It only stopped it was only the LLC in bankruptcy, so it only stopped the sale against the LLC. And the secured lender went to the sale, bought the membership interest, called the debtor's lawyer up and said, I now own the debtor. I want you to dismiss this Chapter 11 case. It was sweet. At which point, my client bought the asset outside of bankruptcy, and it was a thing of beauty. So yes, it can be done. It has been done.
But question is the court that you said, is it in the Oregon LLC Act, or is it somewhere else in Oregon law that allows this currently?
What it is that in the LLC Act that other states have, there's a provision that says, you know, charging order is the only way you can collect against an LLC. We don't have that provision. And so the people who have done this have relied on the fact that you can just execute on personal property generally, whether through Article 9 execution sales or through judgment debtor or sheriff execution sales.
So
so they use other law to do it because there's nothing to prevent it right now.
Could that have been an unintentional consequence of how Oregon's Act was drafted? Because it's not inside the LLC Act.
Oh, yeah, that's probably right. Nobody thought about it at the time because nobody thought about charging orders much at the time. They only put 3 sentences in the first place. And they never thought about what would happen if charging order wasn't enough or didn't work. Or that anybody would ever want to do this, because there's good reasons not to do it most of the time. But this is what I like about this section, is that it preserves the right to foreclose the lien, but it requires a showing that you can't otherwise get the judgment debt paid in a reasonable period of time. So it puts some colors around it that we don't have, that I think are sensible.
But I'm going to try to enlist the other business lawyers on the line here. Sorry, Teresa, because I know where
okay.
But fundamentally, do we want to be a state that allows foreclosure on membership interest versus being a state that does not? And many of those states that do not are, you know, obviously desirable for formation purposes. A lot of us business lawyers sometimes look at the form in states where it's clear in the law that you get a charging order and you can get nothing more. You cannot foreclose. So fundamentally, I want to put on the table for everybody on the phone, do we want to have this extra step of foreclosing the lien and selling the interest, or do we want to back away from that? And I tend to favor backing away from that for obvious reasons based on what I do in my practice. Anybody else?
But I think it's really important that we're clear about what can be foreclosed. It is not the membership interest as Rolka defines that concept. It's only the economic interest that can be foreclosed.
It's the transferable interest only, right?
Yeah,
So
there's no management rights that are foreclosed upon Under current Oregon law, it's kind of an open thing, and because it's open, the creditor can seek a complete foreclosure of the entire membership interest, including management rights. But under ROLCA, you can never do that. You can only foreclose on the economic rights alone. I think ROLCA A is more consistent with national law on this, and I think it's a better system.
And Jeff, I understand where you're coming from. You know, we certainly, because again, it gets to what Teresa was saying about the pick your partner idea, right? If you go into business with these people, you want to feel that you're going to be able to continue in business with these people. But, you know, I think we made a decision fairly early on in the process that to the extent that we had current Oregon law or practice that was in a particular area, we were going to try and be respectful of that. And I do think that current Oregon practice is similar to what is reflected in this section, right? So it may be a policy decision that's above our pay grade to the extent that we want to change that.
Yeah, and that's what I was going to bring up. It's maybe we should flag this for, you know, the legislative question, and bringing up Jeff's point that it may affect, I guess the word is marketability of Oregon LLCs, but that it's consistent with the way Oregon law is now.
Yeah, I mean,
Well,
I
actually think it's backing off of what Oregon law is
Jeff,
now.
I agree with you.
For two reasons. Because one, it limits the circumstances when you can do it to those in which a charging order will not pay the judgment within a reasonable time. And it only allows you to take the transferable interest at sale, as opposed to right now taking the entire thing. So it does back us away from Oregon law, I think, in a way that makes sense, consistent with, I mean, if an existing member, Jeff, can transfer their interest, then why can't their creditor come take it? If they can do voluntarily, why can't it be done voluntarily against them? It's all the same to the LLC, whether it happens voluntarily or involuntarily.
And this doesn't change the ability of the LLC to be sold, merged, convert, what have you. It just changes that judgment debtor member's check, the final check they get from that sale transaction. Does it go to them or does it go to their creditor? It doesn't affect the ability to affect any transaction regarding the LLC, I don't think. I mean, tell me, I'm curious business, you know, lawyers, tell me if I'm wrong on that, but in terms of that making a sale of that LLC or its assets less desirable, but this just changes who the check goes to.
I'm curious what Michael and James have to say about this.
Well, I think it's, Valerie, you pointed out sort of the I guess the modern trend that's reflected by ROLCA, and I don't think this section is necessarily inconsistent with Oregon law in practice. I think, you know, and I think it clarifies what I guess to me has always been an ambiguity in the Oregon statute, is how far you can really go.
Right.
And so this is one area that I think is not necessarily inconsistent with Oregon law, but certainly as you look at ORS 63, fills in an ambiguity that we currently have. And so I guess I tend to like that result. I don't think in terms of marketability, when you look at sort of business transactions, I don't know if this has a depressing effect, you know, because I don't think in most transactional issues, this is something that the parties are really concerned with. They do their due diligence. Obviously, if you have a problem child member, that's a different story. But absent those scenarios, I think people do their due diligence based on the economics of the company.
Well, and another factor here is if that one member that has their transferable interest foreclosed upon, then as we'll be discussing shortly, that under the default rules is sufficient ground for the other members to dissociate that judgment debtor member and, you know, kick them out of the LLC entirely. that can be changed by the operating agreement, whatever the members want. But to agree that this member is a poison pill member or something, the foreclosure in some ways will help those other members get rid of this person because it'll let them kick them out.
I would agree with Michael too. I don't think this is an issue that really comes up when you're organizing a limited liability company, and that I don't really think it affects marketability at all. Everybody thinks their company is going to be highly successful, and they've done a great job of picking their partners. So they don't think of the worst case scenario. Perhaps they should, though.
Nobody expects the Spanish Inquisition. James?
Yes.
So I tend to agree. I think RULCA is an improvement. I think frankly, it's consistent with how we typically draft operating agreements. We try to say that if a judgment creditor comes after a member, all they get is the transferable interest, the economic rights. I always put in there, they don't have voting rights. They don't have information rights to the extent we can limit all that. And I hope for the best, but I don't know because the statute's not clear. So I like that this is at least clear. And I think on the marketability question, the people that are asking, where do I go to make sure that my LLC is respected and that nobody can enforce their judgments against me, also against the LLC, or to get my interest in the LLC? The people asking that question as the first, like the top priority, they're never going to form their entity here anyway. They're always going to be in, Nevada or Delaware or one of the other usuals.
And this is Jeff. This is a good conversation. I raised as a policy question, and we're having that policy discussion. And again, as James just indicated, there are states, Nevada, Wyoming, that are very clear as a policy decision, they won't allow this. And I just wanted to make sure we at least flushed out this discussion before we moved forward on it.
Oh, and one thing that I think was interesting, I was looking at this because, I represent creditors often enough and have often been frustrated at the weakness of the charging order as a remedy. Yesterday, I was looking up law review articles and things like that, talking about the charging order. And there's this one 2018 National Institute of Business or National Business Institute report talking about LLCs as asset protection tools and proudly touting how weak charging orders are. And this is a quote: "Charging orders are so weak, many creditors don't even try to use them." And then regarding foreclosure of that charging order, painfully little for the creditor to gain by foreclosing. You actually lose a lot by foreclosing. I was trying to figure out what advantage is there to a judgment creditor to foreclose a charging order. And the only advantage that I could find anywhere in RULCA is that depending upon what the operating agreement says, maybe that empowers the other members to expel the judgment debtor member for whatever that's worth. So I kind of, part of me is like, why would you foreclose? One thing I noticed, they're up until the very last draft of RULCA, RULCA was including a provision that had existed in the Uniform LLC Act of 1996, and which many states adopted, which says that a transferee can seek judicial dissolution of the LLC on essentially the same terms that a member can. Whether there's fraud or illegality, not practicable to carry on the business, that kind of stuff, oppression. And in the very last draft of RULCA, they yanked that and said that transferees can no longer seek dissolution. So as far as I can tell, the only potential benefit is this ability to kick out that other member. Part of me was wondering, should we include, should we reinsert what was taken out at the last minute in the RULCA drafting, this ability of the transferee to seek judicial dissolution? I can imagine a lot of instances where that wouldn't at all be appropriate. You have an LLC with 20 members or something like that. But I can also imagine scenarios where you have husband and wife are the two members, and they just, they own their house in the name of an LLC and all that kind of garbage, or it's two buddies or it's two buddies and their wives or something along, some super small, tightly knit, they've got a web of LLCs and they just kind of sort of let them all sit dormant while they hide their money elsewhere and shuffle it around. But I think
How do you
having
really
this
feel,
ability,
Cody?
huh?
How do you really feel?
Yeah, oh, yeah,
He's
it's
right,
frustrating. I
though.
mean, it's like what, you know, Teresa knows how this
He's
stuff
so
happens.
right.
And when you're holding that charging order, what you can do with these other necessary orders and this ability to make the inquiries is you can find out how they're transferring the money or not, or, you know, it could well be that this LLC just doesn't get any more money at all anymore. They just form some other LLC to do whatever else they're doing. And, you know, then you're sort of chasing down these fraudulent transfer claims and things like that that are expensive to bring. So part of me liked the ability in sort of, you know, what you might call extreme cases to seek dissolution of, you know, because the LLC is maybe owning their house and there's a lot of equity there. And now they're just, you know, it's just sort of a fake LLC from the start anyway. But maybe you can seek dissolution and having the court have that ability to say, well, this is sort of an extreme case. We're going to order there's nothing good that this LLC is doing or what have you. And it's, you know, it's just these close people who are just trying to, you know, essentially defraud the creditor. It may be a cheaper, easier way than bringing some kind of other unlawful, you know, because then maybe there's not a transfer or something. Anyway, I thought that maybe the ability to seek dissolution might be the only thing that would be a tangible benefit to foreclosing. And I couldn't find an explanation why it was dropped at the very end of the ROCA drafting process. So I thought I'd throw it out there and see what people think about that.
You know, I think the other reason that I could see foreclosing is if for whatever reason your judgment debtor died, or, you know, something happened where it's the easiest way to clean up the right to the stream of payments.
Yeah. But I guess how is it not clean before?
You know, I think you're right. And I think this is why we don't see a lot of these foreclosures between, you know, taking a membership interest with who knows what kinds of tax hairballs attached to it, the fact that you lose rights to information by foreclosing, that, you know, most institutional lenders have regulatory reasons why they don't want to own stock and membership interests and that kind of thing. I mean, you don't typically see somebody want to do this. It tends to be fairly extreme circumstances of the type that you're talking about. You know, the husband and wife who have 17 LLCs and they just shuffle everything around between them until all of a sudden, you know, they think they've isolated the assets from you. So, I mean, frankly, I'd be in favor of having a transferee be able to have dissolution rights in the context of an LLC operated in bad faith to try to hinder creditors. But I think that's going to be a difficult push to try and get through.
I forget what, you know, maybe David or Valerie, are you guys doing who's doing dissolution? I don't know if anyone's looked at.
We're doing dissolution.
Under current Oregon law, who can seek judicial dissolution?
Yeah, we're doing that, but not today. So we can put a pin in it and get to it. I think it's in the 700s. Where is it?
I think it makes sense to put a pin in that question about who can seek dissolution.
Yeah, that sounds fun. That was the only thing I was kind of thinking about, you know, this with regard to 501 or 503C. I was going to say 501c3, but 503c about, you know, upon a showing that distributions under a charge owner will not pay the judgment, you know, you can transfer, but then maybe, you know, we make it be when we get to 701 that person can then be authorized to seek dissolution.
Right. I mean, because that implicates 63-621. So we'll get to that probably not, but not this time. Hopefully next time.
Cool.
Yeah, I put a mark there.
Yeah, and I put it posted on mine. So I'll make sure we address that, Cody. Okay.
So my recommendation is that we adopt 503C.
Any opposition? All in favor? All right. So,
Okay.
so done.
So D and E are in some ways how to avoid C. So if the judgment creditor starts a foreclosure, what C does is say that the member can stop that by paying the judgment. And what E says is the LLC can stop that by paying the judgment. If the LLC pays the judgment, then it will subrogate to the rights of the judgment creditor.
Right.
And the primary advantage to these two sections is that it means that nobody has to go to court to dissolve the charging order, because once it's all, the judgment is paid, it's just done. And it makes it clear what should be clear anyway, which is once you've paid off the judgment, that the foreclosure doesn't happen. That's pretty obvious under every other kind of foreclosure that we have, whether it's Article 9 sales or real estate foreclosure or lien foreclosure under Chapter 90 or whatever. So to me, these two sections are pretty straightforward. I don't know if anybody had any comments about them.
Oh, I had one question about D. I'm fine with all the rest of 503. My only question about D is, I found it odd that it's the judgment debtor who's filing the satisfaction of judgment. Normally that's something the creditor does, at least in my experience, and that way, it's sort of the creditor has to say that the judgment was satisfied rather than the debtor saying, oh, by the way, I satisfied that judgment, which they may be lying about.
That's a really valid point, and I'm not sure whether the court would even file a satisfaction of judgment that was only signed by the judgment debtor.
Right, although they would if they looked at this statute, which says that they kind of have to. I mean, I would just end the sentence at may extinguish the charging order by satisfying the judgment. Because we already have a statute in 18 that requires the creditor to file a satisfaction promptly after the judgment is satisfied. And I would just refer, may extinguish by satisfying the judgment and having the creditor file the satisfaction.
Yeah, I actually agree with that. I had not thought of that, but I agree with that. Or what we could do is, instead of ending the sentence there, we could add, may extinguish the charging order by satisfying the judgment and causing the judgment creditor to file a certified copy of the satisfaction. And it's not a certified copy that you file anyway. I mean, that doesn't even make any sense. So I think, and causing the judgment creditor to file a satisfaction with the court that issued the charging order.
I think
that's what that
much
really
better.
should say.
But is there, with that, if there's a dispute on the amount owed?
Well, if there's a dispute, then, I mean, that's exactly why you shouldn't be having judgment debtors just go around filing satisfactions. It's the creditor's judgment. And until they agree that it's been satisfied, then it hasn't, or at least until they agree or a court adjudicates it, then it hasn't been satisfied.
But then again, causing the judgment creditor to file, if you're the debtor, that's a little bit of a concern. Maybe it's better to just end with the word judgment and rely on the other statute where the creditor is required to file.
Well, I mean, that's what you do is you would go to the judgment creditor and you'd say, I just paid you in full, you must file the satisfaction of judgment. And there's a requirement to do that. It's not like the judgment creditor gets a choice.
Is it a kind of a timing thing? What if we said by satisfying the judgment when the judgment creditor, I don't know, maybe that doesn't quite work, but are we concerned about when the foreclosure goes away? Is it only when the judgment creditor has filed a satisfaction with the court?
But it's not the foreclosure, isn't it? Really, an outstanding charging order that's got to be closed down.
Right.
Right.
So I think this is right, because what we would do, if you're the creditor and you just got paid in full, you would ordinarily just issue your satisfaction of judgment, or if you didn't do it, the judgment debtor would send you a letter and say, you must do this, and you would be required by law to do it. But you would discontinue your foreclosure sale if you thought you were paid in full. I mean, you wouldn't, no lawyer would continue a foreclosure sale after their client got paid in full if they knew about it.
Right, I mean, that's a contrary to statute to do that.
Right,
So-
you'd get in all kinds of trouble for that. So,
Right. The issue is not stopping the foreclosure at this point. The issue is clearing title, if you will, which means essentially shutting down an outstanding charging order. You got to get something into the court record that says it's been satisfied. And that
Right,
shuts
Right,
and
because
so
you
I
have to
think
get
what we're-
notice to the LLC. Like the LLC ultimately has to be freed from this court order.
Right, and the way to do that is to have the satisfaction filed. And I don't think we want to mess with the law that says the judgment creditor is the one that has to file it.
Right.
So I think this makes it consistent with Oregon law. So the change in the language would be, may extinguish the charging order by satisfying the judgment and causing the judgment creditor to file satisfaction with the court that issued the charging order.
So again, why would we not just end after the word judgment in that sentence?
Because the word causing, I'm with Valerie on that, causing, so you're saying the judgment debtor has to cause the judgment creditor to file this action. And that's, I don't know. I mean, these people were in dispute, one just paid the other. It just seems odd to me to use the word cause.
Well, and if we already have a process, I mean, do we already have a process for
We
demonstrating?
already have a process. I mean, we could end it after by satisfying the judgment.
Yeah, I just think that's cleaner.
Can I make a comment on that? Just, I would be lost and not know that that the other law existed. So if you can like, at least like refer to it so that so that the judgment creditor would know that.
Well, but I mean, I think the situations where you're likely to have this, you're going to be dealing with counsel who would already know.
Oh, okay.
I mean, it's a valid point, but I don't want us to be creating two different paths for how a judgment would be satisfied. I mean, that's my concern, is that if you have, are we diverting from the flow here if we create this other language?
What if we put it in a comment?
Yeah, I think that's perfectly valid.
Well,
Yeah.
here's why I think it's important to have a satisfaction of judgment on file. Because let's say that you have a foreclosure sale scheduled for Wednesday at 9. And the judgment debtor short pays the judgment. They pay what they think they owe, but they don't pay the whole thing. And the creditor, because they believe they have not been paid in full, goes ahead with the foreclosure sale. Then the judgment debtor says, but I paid you, and you have to have that fight. And in the interim, the LLC doesn't get to know who owns, doesn't have a clear decision as to, you know, what the status of the world is, whether this judgment is satisfied or not, and frankly, who owns the membership interest at that point. And so the LLC is stuck in limbo. And I think the reason that they included having a satisfaction of the judgment on file is because it puts the burden on the judgment debtor to make the record clear before the foreclosure sale happens. If you're going to stop the foreclosure sale, you have to have the satisfaction of judgment on file, because that way the LLC will always know exactly who owns the membership interest. So I actually think this is helpful to the LLC to have the satisfaction have to be filed. And so I want to keep the second half of that sentence. If the word causing is causing problems with folks, and it's not ideal. I don't necessarily feel like it has to be that word, but I mean, causing a satisfaction of judgment to be filed with the court. I mean, it's got to be a valid satisfaction of judgment. And the reality is only a judgment creditor can file a satisfaction of judgment.
Well,
That's what I'm saying, is this creating some sort of duplicative process or unnecessary additional language where if I had if I had this debt and I wanted to show that it had been satisfied, what would I do other than file a satisfaction of judgment?
Well, you would just testify I paid. I mean, that's the problem. Is that going to be enough? Well, I paid the $18,000 that was owed. Well, did you? Did the check bounce?
Maybe we can just enter, what if we were to just add, this may be simpler, after the word satisfaction there, what if we, certified copy of the satisfaction, what if we just entered satisfaction from the judgment creditor? And that makes it clear that the satisfaction has to come from the judgment creditor.
Yeah, or I was going to suggest even kind of same thing in line with what Cody's saying, maybe a little cleaner is it would say charge order by satisfying the judgment period. Upon satisfaction of the judgment, the creditor will file a satisfaction of judgment in the court that issued the charging order in accordance with applicable law. Something like that. In other words, second sentence that says, because I don't like the word cause in the sense of, at that point, it puts the obligation on the debtor to cause the creditor to file it. What if we just cut the sentence off and add a new sentence and just simply says that the creditor, once the judgment's satisfied, the creditor must file a satisfaction of judgment with the court?
Because then you're messing with ORS chapter 18. So I just pulled this up because I wanted to look at it. So generally what happens is if you're going to have a satisfaction, it has to be executed by the judgment creditor. So ORS 18-225-2 says, when the money award portion of a judgment has been fully satisfied, the judgment creditor must, A, file a satisfaction document for the full amount of the money award portion of the judgment in the county in which the judgment was entered, and B, deliver to the judgment debtor a satisfaction document for the full amount of the money award for every county in which the judgment has been recorded. But you also have 18-235, which is what you invoke if you can't get a satisfaction from the judgment creditor. And let's use kind of a classic example. The judgment creditor is a bank. The bank has failed. You pay the FDIC or the successor bank or whoever ends up with the right to payment, but you can't get somebody to sign a judgment satisfaction for you. So what you have the right to do under ORS 18-235 as a judgment debtor who's paid a judgment in full is to file a motion with the court and ask for an order declaring that the money award has been satisfied. And then if you satisfy the court that you've done that, the court will issue that order and that acts as a satisfaction judgment. So
you're never going to get that hearing. I mean, isn't that hearing going to take 6 weeks and your foreclosure sale is probably noticed for 2 weeks? I mean, the timing issue is
probably
what's
take it
bothering
to
me
ex parte if you can't find the judgment creditor. I would think you could get it.
What I don't like is the satisfaction process doesn't have any deadline in it. It just says the creditor shall. And the part that I'm still hung up on in the ROLCA section is it talks about having a certified copy. I mean, if I'm the debtor and I'm scrambling to collect the money because it's 2 weeks notice or something of the sale of my membership interest, I show up the afternoon before or the morning of when the sale's at noon, there's no way that satisfaction is going to be filed, certainly not getting a certified copy quickly. How do you, I mean, what is the deadline for actually paying? Is it weeks before?
Well, I mean, those are practical questions, right? Because it happens that you have people come to foreclosure sales and try to pay the judgment. So in real property foreclosure, if you're doing a non-judicial foreclosure, we actually have a statute, and it says you have up until 5 days before the sale to pay the amount due. And if you don't pay the amount due within 5 days before the sale, then the creditor can proceed with foreclosure. So if the debtor walks in 2 days before the sale and hands the creditor a certified check for the full amount that's due 2 days before the sale, the creditor does not have to accept it. Now, as a practical reality, they will. What they do is they say, I'm going to postpone the sale for 10 days. I'm going to take this check. I'm going to make sure it clears. And if it clears, I'll cancel the foreclosure sale, right? So as a practical matter, that's probably what happens. If the judgment creditor is convinced that it's not the right amount of money, if it's $100,000 short, then they may or may not accept the money. They may decide to proceed with the foreclosure, or they may decide to take what they can take and see if they could work with the borrower. And that really is going to depend on the case. I think it's going to work the same way here. If somebody wants to come to the foreclosure sale with a check and say, I want to pay you off, I think the judgment creditor is going to have the power of saying, yeah, I'll take the money and give you satisfaction now, or I'll set over the foreclosure sale to make sure the check clears, or no, I'm not going to do it because you waited too long and you can't complete, you can't do what needs to be done, which is get a satisfaction entered. But I think the burden should be on the debtor to get a satisfaction entered in order to stop the sale.
But you could literally show up with more money. I mean, you could overpay.
You could, and then the creditor has to give you a refund.
Again, it's just the timing thing, because there's no, it doesn't say when the creditor has to do anything. So how do you know as a debtor, what is my deadline?
Well, I think the 5-day thing, Teresa, you were talking about, I think it's for non-judicial foreclosures.
That is correct, for non-judicial foreclosure. For judicial, you don't get any right to.
Right, but when you're doing this charging order foreclosure, that would be a judicial foreclosure. That's not going to be a trustee's sale because it's a non-consensual lien. And so I think the judgment debtor is going to have the ability to pay the judgment, to satisfy the judgment up until the time that the sheriff, holds that sale and sells that property to somebody else. So you're going to be able to be there that morning of and effectively block the foreclosure. And even though this statute says that the charging order isn't extinguished until both you've satisfied the judgment and the copy of the satisfaction is filed with the court, as a practical matter, other law is going to prevent the judgment creditor from holding a foreclosure if you've truly paid off the full judgment amount.
You're right, Cody. The fact that it's a judicial foreclosure totally solves it for me. The court can.
Yeah, because the sheriff will have obtained from the judgment creditor a copy of the judgment and the payments made on that judgment, and will have you have to compute for the sheriff the exact amount that's due, and they put that out in their notice. The notice will say, here's the amount that's due as of this date, plus interest from the next day forward until the date of sale.
And I've had foreclosures before where the judgment debtor contests the amount that we have told the sheriff is owing, and we've had, we've postponed the sale and had a court hearing to determine what is the proper amount they're going to have to pay off this judgment before the actual sheriff's sale. So I think that disputes about how much is owing will get resolved before there's an actual foreclosure sale because it's all judicial.
Yeah.
No, I still think though that we should, I guess two thoughts. One is I feel like adding after the word satisfaction from the judgment creditor would resolve this issue about, I don't want the judgment debtor to be filing a satisfaction. And what do you do if you can't get that satisfaction from the judgment creditor? Then I think we could, if we're worried about that, we could say filing a certified copy of the satisfaction from the judgment creditor or a court order ruling that the judgment is satisfied with the court that issued the charging order. I think that would be sufficient to resolve.
Maybe what it should be is instead of by satisfying the judgment and obtaining satisfaction of the judgment with the court that issued the charging order in accordance with the provisions of ORS Chapter 18. Which means either the judgment creditor does it or you do the motion.
I like that.
In other words, just punt it to Chapter 18.
Yeah, I like that too.
So can you say what the text was you had?
Yeah, so it would say by satisfying the judgment and obtaining satisfaction
how about
the judgment with the court that issued the charging order in accordance with ORS Chapter 18.
Is it obtaining satisfaction or obtaining a record of satisfaction?
Well, I would suggest saying, and obtaining a satisfaction document, which is the words that Chapter 18 uses, by obtaining a satisfaction or court order under ORS 18.225 to 18.238.
You know, I think we ought to leave it to the legislative council exactly how to say it, because I think they're going to do it however they're going to do it anyway. I think we just need to get the concept to them that it's obtaining satisfaction of the judgment with the court that issued the charging order in accordance with Chapter 18. And then if they want to change the word obtaining, or they want to refer specifically to 18.225 and 235. I mean, there's other provisions in here like 18.228 and 232 that have to deal with judgments owed to the Department of Justice. I don't want to not include those, even though they aren't the most common way that this is done. To the extent that the Department of Justice has judgments, they do it differently. So that ought to be accounted for too. So I'm inclined to just get the concept in front of the Legislative Council and let them figure out the language.
I think that's really good. And also, you know, here we're working with Chapter 63. We're changing stuff all around, and well, whereas 18 may be fairly stable in terms of the overall what it covers. I think it's really good not to, at least that we shouldn't be nailing it down to particular provisions.
Well, right. I mean, I don't want us to create a separate process. So Sandy, did you get all that?
Yeah, I have potential language connected to 18 and flagged it for LC. So I think we're in good shape.
Yeah. And I'd like to point out that we should have just listened to Talitha in the first place, because like 20 minutes ago, she said this is what we should do. So my bad. All right.
Okay, so my recommendation then is that we adopt D with those changes and E as is.
Yeah.
Okay.
I'm good with that. Yeah. Anybody have any objections? Speak now or forever hold your peace.
Okay. So then we get to F, and F has to deal with single member LLCs and foreclosing the interest of single member LLCs. And we actually have a similar concept to this subsection in ORS 63, 265, 2B. And what that current ORS says is, if the member who ceases to be a member is the only member of the limited liability company, the holder of the former member's interest shall become a member simultaneously with and upon the cessation of the former member's interest, which is kind of a cumbersome way of saying, if you take over a single member LLC, you get to be a member because who else is? And what
Hey, Cody, by the way, there's an example where you might foreclose. If you had judgments against 2 LLC members or 1 LLC member, might you not want to foreclose to eventually get the full membership?
If it's a single member LLC, then foreclosure is good. I just feel like there's very few single member LLCs. You're right. Yes, a single member LLC. I guess maybe you're saying like if you have a judgment against both members of a 2-member LLC, then foreclosure would be good. Does that?
That's what I was thinking.
What do you get if you do that?
Well, actually, that's a good point. That's a good question. I probably shouldn't have interrupted you, Teresa. I apologize. But I'm wondering if we have an analog to 265 in ROLCA that would have the same effect, so that if you did end up with both of those ownership interests, you'd eventually be the sole.
I think that's going to end up being in the disassociation provisions that we're coming to next in Chapter 6. So I think we probably have other people talking about that, Valerie and David, later in terms of dissociation. But I think the reason I think the concept is similar is the idea that if you have a single member LLC and you become the owner of it, then you should get to be the member, because somebody has to be the member so that you can do something with it. And what F says is, if you foreclose a single member LLC, then you get to be the member, and then you have the rights and own the LLC and move forward, and your judgment debtor does not. That makes all kinds of sense to me. And really what F does is spell out how that happens. It says the court shall confirm the sale. The purchaser at the sale obtains the entire membership interest, not just the transferable interest. The purchaser becomes the member, and the person whose interest was foreclosed is disassociated. It kind of just puts it all in one nice, neat step. And to me, this makes a lot of sense.
And I'll just point out that this particular provision is also, I think, consistent with current Oregon law at 63.235. And it sounds fine.
Oh, okay. So any comments on this section? I recommend that we adopt it as is.
F. Okay.
Seeing thumbs up, so we'll go with that. Subsection G is an analog of the last sentence of ORS 63.259. Because the last sentence of section 63.259 says this chapter shall not deprive any member of the benefit of any exemption laws applicable to the member's membership interest. And 503G says this act does not deprive any member or transferee of the benefit of any exemption law applicable to the transferable interest of the member or transferee. So I think we should adopt this because it's consistent with Oregon law and it makes sense. It just preserves our normal exemption schemes, which it should. All in favor? Thumbs up.
It's a stupid question. What is an exemption?
Oh, so when you're collecting on a judgment, there are certain things that humans own that are exempt, because the idea is that you have to leave people the shirt on their back and enough to live on at some bare minimum level. So we have homestead exemptions, we have exemptions in people's cars, we have exemptions in life insurance policies, we have exemptions in a certain amount of groceries and firearms, and there's a whole laundry list of stuff in chapter 18 and then sprinkled throughout the Oregon revised statute of things that are
You just took me back to my bankruptcy course. That's good. Got it.
Well, there's a whole separate scheme of exemptions in the bankruptcy code. And people get to choose whether they want the state law exemptions or the bankruptcy code exemptions now, which is a new change in the law in the last 10 years. So
thank you, Cliff,
yes.
for that can of worms.
So the point is, we're not messing with any of that, which I think is good. Yeah. So adopting G. And then finally, H. Says this section provides the exclusive remedy by which a person seeking in the capacity of judgment creditor to enforce a judgment against a member or transferee may satisfy the judgment from the judgment debtor's transferable interest. And what this is saying is you don't get to make up other remedies. It's got to be within the scope of this section. But more importantly, what this says is if you're acting in the capacity of a judgment creditor, you have these limitations, but it is not creating a limitation if you are acting in the capacity of some other type of secured creditor with a right to foreclose an interest or a right to claim an interest. So if you are a secured lender with an Article 9 security interest in the membership interest of the LLC, you can still follow whatever Article 9 rights you have. Or if that has been awarded to you in some way that's not a judgment, if you have a, I don't know if it's certificated membership interest and you have a storage lien against that certificate, which I can't imagine how anybody would ever want to assert, but I suppose they could. You could use the storage lien laws to exercise your remedies. So I think it's helpful in that it says we're not trying to displace Article 9 effectively,
but
or
Teresa,
other law.
I don't necessarily get that from the language in the proposed code, but I get that from the commentary. So this may be
it comes from the clause seeking in the capacity of judgment creditor.
No, no, I
But
understand.
there's a limitation, but it only applies if you're in that capacity, meaning that the limitations don't exist in other capacities.
Right. No, I understand that, but I think this may be one of those circumstances where, for clarity, we explicitly adopt that comment related to subsection H.
I'd be in favor of that.
Yeah, I'm fine with that too. Is there a definition of judgment creditor in the LLC statute?
That's going to really be defined in ORS 18. I think I don't remember that ROLCA addressed judgment creditor, but
I don't know that it would. I mean, we don't want a different definition than they have in the rest of the.
yeah,
statute.
they don't in section 102. I think you would look to chapter 18 to determine who is a judgment creditor.
And I think that any court interpreting what we're doing here, to the degree that people get to commentary, they're going to look both at the commentary to ROLCA as well as our own commentary. And I think it's fine to say we sort of extra agree with comment H, but otherwise I think generally people are going to assume we agree with all the commentary in ROLCA except for where we make different language in the actual
I think that's fair. I'm just concerned that, you know, when we're highlighting things for legislative counsel, we want to make sure that we are in certain areas where we're particularly concerned that we want clarity, that we highlight the comment, say, well, this is where we're hoping to go. So don't change that, you know, that language in H that says in the capacity of, for example, even if it is consistent with Oregon style.
Yeah.
Yes, I agree with that.
Okay.
So
Okay. Anything else?
I recommend that we adopt H.
Yep.
Okay.
So
And
that
then-
wraps up this section, but there's one more provision in 5, but I'd like to propose that we take a break, a 10-minute break, and come back and finish 5 and then start 6. If that
Sounds
works
good.
for everybody.
Yeah, I have
Teresa, you are a rock star. Thank you for doing
great
it.
job, Teresa. I have 10:45 now, so 10:55 to come back.
Yes.
Sounds good.
Okay.
Sounds good.
Okay. So picking up with section 504, we actually already talked about section 504 sub 2 when we talked about section 410. So we only need to talk about section 504.1, which says if a member dies, the deceased member's legal representative may exercise the rights of a transferee provided in section 502C. To me, that's kind of a no-brainer. So I recommend that we adopt that.
Works for
And
me.
I see other people agreeing with that. So we've now finished section 5.
All righty. Excellent. Thank you again, Teresa. That was really helpful. So David and I are going to talk about section 6, which is the dissociation provisions, or at least we'll get started on them. I'd like to wrap this up by about 11:30 if possible, because I know that folks have a lot of other stuff going on. So we'll see how far we get. I mean, there's not very many sections, and I think they're fairly non-controversial. But, you know, I've thought that about other sections that have been more controversial than I thought. So we'll see. But effectively, what section 6 does is it introduces this new language that I think previously we've been addressing in operating agreements for LLCs. That, you know, what are the situations in which a member may dissociate, and how does, you know, what does that mean and how does that happen? The parallel that I was able to find are primarily in section 63.205 and 63.209. If you want to, let me pull those up.
And I think also ORS 63.265 as well.
Yeah, so just to give you a bit of an overview. So so 63, and David, absolutely leap in, or, you know, if you want to talk and I can be quiet, that's okay too, and people would probably appreciate it. But 63.205 is where we're talking about voluntary withdrawals of members. And, you know, so section 601 talks about, you know, situations in which a member may have the ability or authority to disassociate, as a member. And it essentially just says that they can do so at any time, rightfully or wrongfully, by withdrawing as a member by express will under section 602 L. No, 1, sorry. They changed my reading prescription last week, so it's been a bit of an adjustment. And so that is the corollary. There is going to be 63-205, which just basically says a member may voluntarily withdraw from a limited liability company. And then, you know, it doesn't specify, well, so 63-205 specifies, says, you know, at a time or occurrence specified in the articles or upon not less than 6 months prior written notice, unless the operating agreement says no. So, you know, so we have a process already by which a member may voluntarily withdraw that is expressly, you have the ability to limit in the operating agreement currently. You know, and so I think that's very similar to 601 sub A.
So let me interrupt in one regard. So I think the other thing too is, just as an introduction to this section, is that I think, one, it's a big improvement over the current state of Oregon law. And second, for purposes of this conversation, I looked at what 2 other states did on this. One, I looked at the state of Washington. The state of Washington did not adopt Article 6, the ROLCA. The closest thing they came to adopting was section 602, and their statute is set forth in RCW 2515-131. And it resembles and they call it member disassociation. And then it resembles to some degree section 602. On the other hand, I looked at Idaho as well. It adopted verbatim this statute, these 3 sections, with the exception of 602. They actually added one more ground for wrongful dissolution, or disassociation. So I'm now rudely interrupted. So
no. I think that's very helpful, because, you know, we've seen in other areas that we've talked about already that Idaho generally conformed more strictly with the ROLCA language as it stood, whereas, you know, Washington was much more of a deviation from that. To the extent that Oregon cases have looked at this, I think what they've generally concluded is that the operating agreement has the ability to govern this. You know, so I think just giving a little bit more color around it, which is what Article 6 does in my reading of it, I think is generally an improvement. So anyhow, so that's background on Article 6.
Right.
Any thoughts or questions about dissociation in general? Okay. So 601, you know, as I was saying before, talks about a member's authority to dissociate and what happens if there's a wrongful dissociation. You know, it doesn't talk about the mechanics of how that happens. That's addressed in section 602, which is the events causing dissociation. So, you know, we'll talk about sort of how that mechanically happens, and, you know, what sort of some of the distinctions that they make. It's a pretty long section, but I don't think 602 is a very, I don't think it's a terribly complicated section. But it does reference a lot of other places. Okay, so we know the person has the authority to dissociate under A, but then we talk about B, situations in which a member or a person, dissociation is wrongful. And those would be in circumstances where it is in breach of an express provision of the operating agreement. So again, we're putting the operating agreement ahead, and that's what the current Oregon statute does, put the operating agreement ahead of you know, what they have in here. So basically, if you say you cannot dissociate in certain circumstances in your operating agreement, you're not going to be able to point to something here that would get you out of that. And then
so Valerie, one interesting thing too is on, you know, the subsection A is that under the commentary, the operating agreement may vary. So all these provisions for the most part can be varied into the operating agreement, and including negating a member's power to dissociate. So you could even, under the operating agreement, not let them. The only thing on subparagraph A is they use the expression by express will, and I'm not sure what that means, but I guess it means that you really meant to do it. So
yeah.
Otherwise, I don't really have any issue with subsection A for all.
No, and I mean, this is part of why I think that the whole article is relatively non-controversial, is because to the extent you don't like it, you know, you can change it in the operating agreement, and it very expressly says you can change whatever you want about this in the operating agreement. You know, and if there's better language than by express will,
Oh, no, I
then,
think it's fine. You know, I don't
yeah.
have it. I just never seen it before, so.
Yeah.
You know, I didn't know what it meant either, honestly. I was very confused by that. Does that mean you just come out and say, I hereby want to do this?
So the commentary to 602 sort of talks about that,
Yeah.
where the limited liability company sort of expects to receive some sort of notice. And I think that's what they're talking about there, as
Yeah,
opposed
and-
to sort of hearing it through the grapevine or something to that effect, or
Yeah,
I guess.
and 602 talks about the mechanics of how you do it, right? How you dissociate. You know, and so I think the express will is the manifestation of those mechanics, but we can put a pin in that and come back to it if it's still not clear after we talk about section 6, or if there's better language that occurs to us, because that was the only thing that really leapt out to me. But it didn't bother me that much, to be honest.
I wonder if legislative council would have some suggestions on a better way.
So
to
that's
say
a good,
that,
that's a good point, I think.
because I didn't understand it.
I just, from a statutory construction, I don't think I've ever seen those two words together in a, you know, in any of these statutes that I deal with on a regular basis.
Yeah, and just trying to think about situations in which, you know, you would withdraw by, I don't know, implied will or something, because that would be
I wonder whether, because formation they'll all see as a matter of contract, which can be entered into expressly or, you know, implicitly, or, you know, through conduct. And I wonder whether they just want to make clear you can't withdraw just by conduct alone. It needs to be, you know, an express, I quit.
Yeah, I think you're right, actually.
But and so that makes sense to me, Cody. But then I was thinking, well, you know, what is the use of the word will there then, right? So you'd say express act would be more effective. But we can ask legislative council and see if they've got some better language.
Right. Well, and maybe they also are intending there that it's sort of voluntary, prohibiting any kind of, involuntary withdrawal is addressed elsewhere. So this is what we're talking about. Voluntary.
Yeah, that is fair. Okay, so, and then B talks about situations in which someone's dissociation is wrongful, and those would be if it's an express provision, violation of express provision of the operating agreement. So again, putting the primacy of the contract ahead of anything else, and then occurs before completion of the windup of limited liability. And again, we get this language of express will. The person withdraws by express will. The person is expelled. The person is dissociated under 602(8), which is
bankruptcy, basically.
Pardon?
Oh, basically bankruptcy.
Yeah. So 602(8) is on page 134 and talks about debtors in bankruptcy, signs and assignments of benefit creditors. Yeah. And then in a case of a person that is not a trust other than a business trust, an estate or individual, the person is expelled or otherwise dissociated as a member because it willfully dissolved or terminated. So you can't just terminate and say, okay, I'm done with you people, and I'm escaping all of my responsibilities. So
Valerie, one question I have is, what do you think they mean by willfully dissolved or terminated?
Well, that's what I'm saying, is that, you know, I don't think that you can, I don't think that you can say, okay, you know, I have obligations, but I'm sick of dealing with you people. And I don't want to deal with the other provisions in the operating agreement saying, I have to stick around. So I'm just going to dissolve, and then you can deal with my dissolved entity. So
I think it's trying to distinguish situations where you're administratively dissolved by the Secretary of State because you didn't pay the fees.
Yeah, that's fair. The willful situation.
You know, unfortunately, there's just not a ton of commentary in Article 6.
Yeah.
So I just found a little article, a little blog post about an Iowa Court of Appeals case that was addressing specifically what did it mean to have express will to withdraw from an LLC. And so there was a series of emails oh, you won't have to deal with me anymore kind of thing. And, you know,
It's vaguely suicidal, but okay.
well, yeah, something like that. So anyway, and I don't know, I suspect that Iowa probably has adopted ROLCA. And so anyway, for what that's worth.
Yeah, I mean, that makes sense. And that gets to what Cody was saying. And I think what Cody said makes sense too, is that, you know, you can't just tap out, basically.
Yeah, and I put the link to that blog post in the chat. So.
Oh, thank you so much.
Can I ask a question, which is, I don't understand the difference between B1 and B2A. Like, I get B1. If the operating agreement says you can't leave, you can't leave. But if how is that different than 2A, which says you can't just say you're going to leave?
Well, I mean, I think the distinction is the 2 limits A, right? So it says occurs before the completion of the winding up to the limited liability company.
It's interesting. It doesn't say after disassociation, although I think that, and isn't it? Or I meant, excuse me, not disassociation, dissolution. So you dissolve and then you go into wind up mode. I think it infers that there's been a dissolution in B2.
Yeah, I think so too.
Well,
but
I
then,
agree.
but then you
It's mildly
say,
confusing.
yeah,
Yeah.
but then you say, okay, you know, you have occurs before the completion of the winding up of the limited liability company, and then A, that would make sense with respect to A, but then B, the person is expelled as a member by judicial order. You know, so the A, B, and C, I don't know that it makes quite as much sense if it's just in that narrow window. Or the B, C, and D, rather.
I mean, I guess the question I have is, what if you have an operating agreement that allows people to withdraw by express will?
Mm-hmm.
So they're not breaching the operating agreement by saying they want to withdraw, but then they withdraw by express will.
Right, but I think if you look at the commentary of B, the you know, it says that it's not a, this is a default list, right? So the operating agreement can make a different list. So by making wrongful dissolution, it breaches the implied contract covenant of good faith and fair dealing. So it can provide for other stuff too, right? And then
I would think that if you had a contract provision saying that you can withdraw by express will at any time, that would override both B1 and B2A.
yeah, I think so.
Okay.
Yeah, I think so.
And
that's
on
sort of
that point, I just was going to point out that section 105, which controls what the operating agreement can't do, is silent on these sections. So I think that in the commentary, you draw the implication that you're fully free in your operating agreement to redesign this area.
Yeah, and I think what this gets to is the carpet layers, right?
Yeah.
Where you
Right.
may not have
Gap filler.
Mm-hmm.
Yes.
It is interesting, pursuant to the commentary, how much flexibility you have to define what is a wrongful dissociation. And you can expand it, or you can even contract or eliminate the list of wrongful dissociations.
Yeah.
So it'll be interesting from a drafting perspective if we were to adopt this ROLCA, you know, how, you know, attorneys will address it, or practitioners will address that issue.
Mm-hmm. Mm-hmm. Okay. So bearing in mind that this list in 2 or in B in general is, you know, sort of the default provisions, do we have any concerns that our carpet layers may be injured, or this may not be consistent with what their expectations should be for their entity? And I didn't think so, but I just wanted to float the question out to the group.
I'm curious what the what the other transactional lawyers on this think as well. I assume, I mean, I don't know what the assumption of the carpet layers or other people who are forming LLCs is with regard to, are they anticipating they can bail whenever they want, or are they anticipating they're in it forever, because LLCs are assumed to be perpetual unless you change that.
Right.
So I would think people think they're in it forever. You know, that just would be my guess.
Yeah,
So
and
to this extent, this, you know, proposed language offers greater specificity, and I think ultimately greater protection for the carpet layers to some degree. At least I would argue that.
mm-hmm. Yeah, because we don't really have language that's this detailed in the current statutes. You know, talking about when is it okay to get out, when is it not okay to get out, you know, and I mean, because this is something that we tend to address in our operating agreements, but, you know, again, our carpet layers are not going to have us drafting operating agreements for them. So, you know, I'm generally in favor of this entire article because I think it provides at least some guardrails around when someone can and can't withdraw from an entity, even though, you know, very explicitly we believe that, you know, it says that, you know, the operating agreement is going to control and could trump any and all of these provisions.
Yeah, I wonder, you know, I'm just trying to think of examples. Maybe you have a couple of, you know, carpet layers, and the one is the one who goes and gets the business, does bids,
Yeah.
etc. And the other one actually does the laying, and the one that's doing the laying is counting on that business generator partner to go and do that. And if that one just up and quits, then, you know, that the other one's sort of jilted, and vice versa. Oh, how I got all these quote bids and jobs lined up. Now I can't lay the carpet because my other partner just quit on me. And I can see that you would have damages in that scenario. And that's kind of a thing where you guys would have to, you can't just leave your partner in the lurch in that way.
Well, Cody, wouldn't B2 call that a wrongful withdrawal, B2A?
Yeah.
Right. Yeah, and therefore, if you jilt your partner in that way, they would have a cause of action against you for damages under this.
Yeah, and I think that that's more clear than the language in 63205 that we currently have, which I like, because again, I like that, you know, you can say that, okay, well, you may have quit me, but, you know, there's consequences to that. Okay.
I don't know what other people do, but I large, you know, in drafting operating agreements, there's times I generally will provide that a member can't withdraw.
Right.
Yeah, well, and yeah, absolutely.
But you're having a situation where you know, with the carpet layers, they may have maybe even an oral operating agreement. So it's like they may feel they have the right to, you know, withdraw at any time. Although in Oregon, you would have to give at least 6 months notice. But
yeah, and that 6 months notice, I think is important to keep in mind as we're moving into 602, because they have different timelines in 602 than that 6 months.
There is no 6 months in ROLCA, so
right, exactly.
Right.
So, you know, but I'd recommend adoption of A and B, just because I think that we talked about A, and then adoption of B, because I think it provides at least some guardrails on some guidelines on, you know, how do we move forward. David, do you have any other thoughts on that?
no, I agree with you entirely. So
Just further discussion? Okay. So that's B. And then C, you know, C basically says that if you wrongfully dissociate, so this gets to Cody, what you were saying, if you wrongfully dissociate as a member, then you have damages that you owe to the other members caused by that dissociation, then you're still going to be liable to the other members for that.
So the closest analog to that is ORS 63-205-2 and 3, and which essentially, I guess I would argue, say about the same thing.
Yeah, and it mentions in there section 801, which is the direct action by member provision that we'll get to. You know, which is situations where a member may maintain an action against another member. You know, so I think there's enforcement that we'll see later on in the statutes. But I just think that that's useful, because I think that it puts some teeth around the, okay, you know, you quit me, but there are consequences thing, and explicitly puts it in there, which we don't really currently have, I don't think. So, Okay, any questions about C?
Is there any, maybe I'm just getting out too far here, but is there any limitation on what those damages are?
I mean, I think that's a matter of the litigation, right? To the extent that you'd have to prove what it was.
Yeah.
Right. I mean, it's contract law, you know,
Yeah.
and in the commentary on 132, they say courts should look to contract law to determine what consequential damages are recoverable.
So it also says subject to 801, and I don't actually know what that is, but I don't know whether we need to address that now or not.
Roberta, that's what I was saying, is that 801 is that direct action, so of a member to sue another member. So we'll talk about that, but I like having the reference in here because I think it puts some teeth in the, okay, you're a bad actor and here's how we're going to impose consequences.
I guess the only reason I raised it is, you know, damages, the term itself is so broad. You could be talking about tort actions and stuff like that. Again, maybe I'm out on left field on this issue, but, you know, I'm kind of an issue spotter, and I would be concerned about tort actions and things of that nature coming out of somebody withdrawing and disassociating.
This is contract, but it makes clear it's contract claim.
Yes.
Right.
Yeah, and I think that anybody who's writing an LLC agreement can address whether they want to limit those damages.
Right.
And I mean, this is really basically protecting the people who aren't writing agreements to say that they can sue each other for whatever damages they actually have and can prove.
Yeah.
Cody, where do you get it's just contract law and contract damages?
If you look at the commentary to the section, so it's on page 132, and in this sort of fat paragraph in the middle of the page, in effect, this subsection equates wrongful dissociation with breach of contract. Accordingly, courts should look to contract law to determine what consequential damages are recoverable.
Mm-hmm.
Okay, but so you need the commentary to see that limitation. It's not in the statute. Are we
Right.
Well, let's say that there were tort damages for something like, you know, unjust enrichment. Somebody left because they wanted to go steal a corporate opportunity or something like that. I don't know why you would limit it to contract damages. Damages are damages. If somebody wrongfully withdraws, they have to bear the consequences of that.
Yeah, I agree with that, Teresa. And I think too, we're going to talk more about this when we get to 801, because we're going to talk about types of action between the members.
And I hear what Teresa is saying, but again, when you look at the commentary that Cody pointed out, it doesn't seem like the author Volka intended that.
And what are you basing that on, Jeff?
Well, the commentary. I mean, what Cody just read, it's on page 1302. In effect, this subsection.
Well, if your act of wrongful dissociation constitutes a breach of one of your fiduciary duties, as well as being a breach of contract, then you would be liable under both tort and contract theories. But if the dissociation doesn't violate any of your fiduciary duties, it merely violates your contractual agreement not to dissociate before the LLC is wound up, then there would only be a contract claim.
Right, and I think the commentary to subsection C sort of does state that, I think. I would argue that.
Yeah.
And together with the reference to the cases there as well.
Yeah, I mean, and 801 talks about a member's direct claim against other member for breach of fiduciary duty if it harms them directly, sort of especially beyond the general harm to the company. And in that scenario, potentially a wrongful dissociation may violate a fiduciary duty. And in that case, they would be able to sue you for the tort as well as the breach of contract. And I don't think there's anything wrong with that if you have breached your fiduciary duty. I think the commentary here on page 132 is really kind of focusing on the scenario where you haven't breached a fiduciary duty. All you've done is wrongfully dissociated by virtue of the breach of the operating agreement.
Right. Yeah.
I don't think as a matter of policy we'd want to necessarily limit the kind of damages you could get. I guess I would argue that.
Agreed.
So
Agreed.
maybe I should advocate for a different policy.
I was gonna say, David, we put as many limitations on damages as we can.
Right, yes.
Well,
Because it depends on
It's
which
default
person.
rules anyway, right?
Yeah,
So,
and I
so
think-
you can write into limitation, if you're when you're drafting the agreement, you can write that in. This is for
Yeah.
the
Well, and
carpet layers.
I think that that's a really good point, Roberta. I mean, I think that we're thinking, you know, of maybe more sophisticated clients when we're thinking about, okay, what sort of cause of action would we bring? But again, you know, I think this is a situation where you have to think about the carpet layers, and you have to think about their, you know, what are their expectations and what damages are likely to occur in a situation where, you know, rainmaker carpet layer walks out on carpet layer. So, you know, and I think that implicates 801, which again, you know, we specifically in C say is subject to section 801. So I think that the language that we have right here is sufficient, and I'd recommend adoption with that provision. Okay. All right.
You know, the other thing, wouldn't this commentary also be something that if there was a dispute, the court would actually look at, a court would look at?
Yeah, look at the adoption packet that we have to put together for this thing. I mean, there's going to be other stuff around it. So, okay. So I think that we're generally good with C, and it is, I have 1128, so I don't think we've got time to talk about 602. So I'd like to propose that we start with 602 next time. And Sandy, when is next time, just so everybody remembers?
Just hold on, let me look again.
It's October.
It's October 6th, is that right? And hold on 1 second.
Yeah,
it is
October 6th.
October 6th, normal time.
Okay, so and 602 is a long and fairly detailed section, although again, I think it is fairly non-controversial when you think about it in terms of the carpet layers. So with that forecasting.
So we'll start there.
Yeah.
All right, good luck, everybody.
Yeah, good luck. Roberta, Sandy.
Sounds like you may need more luck.
Yeah, all of you.
Exactly.
If there's anything that we can do, but we'll think good thoughts for you. And if you need anything beyond that, let us know.
Yeah, breathing is just optional, really.
Yeah,
I mean, we're just not breathing. It's okay.
No, there was a new report on our fire. New report on the Mackenzie fire a little while ago. It's not moving west anymore, but the air is just terrible.
Crap.
That's really
terrible.
yeah. I don't really know, but anyway,
Stay inside.
Stay inside. Yeah. Okay. Well, we'll get through this. Hopefully it'll be better times than when we're talking October, but thank you all so much for your time. I know that this is stressful times for everyone. So
like you said, we won't exist anymore. So.
Well, yeah, that's definitely an option too. This does feel a bit
The end
like,
of the world will have come.
Yeah, this might be it.
I didn't know you were a pessimist, David.
What's that?
I said I didn't know you were a pessimist.
Realist. It's a realist, right? I mean,
I just look out my window here and it's like, oh my God. So
yeah,
so Sandy, you'll send out the calendar invites that we need.
Yeah, the October one's already out. I just need to send the November one.
Yeah.
Okay, perfect.
Thank you all so much for a really great discussion today. I appreciate it. And I'm sure that those who deal with charging orders more regularly will appreciate it too.
So I really learned a lot from that as well, because I don't practice that area at all. So that was helpful.
Thank you, Teresa.
Yeah,
Thanks, everyone.
welcome.
Thanks. Bye-bye.
Bye.
Bye, everybody.
Thank you all.
Thank you. Take care.
Bye.